get started. Good afternoon. My name is Sheila Lamb, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 26 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one advising services are available at no charge. Today's webinar, Intellectual Property Fundamentals, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. Be sure to check out the next webinars in this series, Patent Basics on Tuesday, February 27th, and Trademark Basics on Thursday, March 28th. We are recording today's presentation, and it will be posted on our website, virginiasbdc.org. Due to the large number of participants, everyone's microphone is muted and the chat feature is turned off. But if you have questions during the presentation, you can type those into the Q&A box, and they will be answered either via typing with a response, or we will handle those questions live at the end of the webinar. We have also enabled the live transcript function, which you can show or hide via your own meeting controls. And now it is my pleasure to introduce our presenter for today's session, Ramon Mercado. Ramon earned a PhD in computer engineering from Ohio State University, specializing in software, hardware code design for embedded systems. During his time at Iowa State, he actively contributed to curriculum development, particularly in the area of embedded system design. Ramon designed lab exercises aimed at providing students with practical examples to enhance their theoretical understanding. In 2010, Ramon joined the U.S. Patent and Trademark Office as a patent examiner, specializing in computer memory and storage. Alongside examining patents, he played a role in training new hires at the Patent Training Academy. Currently, Ramon serves as the Assistant Outreach Coordinator for the Eastern Region Outreach Office of the USPTO, where he focuses on educating the public on intellectual property and help demystify the patent process. Please join me in welcoming Ramon Mercado.
Well, thank you, Sheila, for that wonderful introduction. We're going to go ahead and get right to it. So, like Sheila mentioned, today we're going to be talking about intellectual property. Okay. Like Sheila, thank you again for that introduction. I've been working for the Patent Office now since 2010, and particularly I've been working with applications that have to do with computer engineering. As you can see, that's my background, so that's where I got hired to do. And this is going to be something that's going to come up later on. You'll see the type of background that examiners have and why that's important. Just to give you a little bit more background, what I do in particular has to do with computer memory storing. So whenever somebody says it's stored in the cloud, now you know, oh, Ramon, that's examiner, he deals with cloud storage. Okay, so let's go. Before we start, we always have to make the disclaimer, okay? We cannot give legal advice. So this is not a legal advice, but it is educational, and hopefully you guys get a lot of good information about intellectual property, how intellectual property is good for your business, and how you can use it to increase the value of your business. Today, we're going to talk about intellectual property as a business strategy. We're going to define what is intellectual property. We're going to talk a little bit about the USPTO. We're going to see the different types of intellectual property. And at the end, I'll give you a few resources that are available for you right now from the USPTO. Okay, so IP as a business strategy. We've all seen the show Shark Tank, right? And we all know that the sharks in Shark Tank, one of the first things they ask after the pitch is, have you applied for a patent? Have you applied for a trademark? Have you invested in protecting your intellectual property? That should give you a very good idea of why we say that IP is a business strategy, because intellectual property adds value to your business and attracts inventors and buyers, letting people know that you have taken the time, that you understand the value that it adds, and that you are taking steps to protect that intellectual property. That shows people that you are putting that time into your business, and that attracts, again, investors and buyers. Okay. Something else that IP can do for your business: deter infringement and lawsuit. by printing the patent numbers on those good patented goods that you have, okay? By using the TM or the register mark on your trademark, by using the C with the circle on the copyrighted works. You're letting everyone, you're letting the world know you have invested in protecting your IP. IP can be used for leveraging. IP is an intangible asset that adds value to your company, just like tangible assets, office space, equipment, etc., etc. Intellectual property also adds value to your government, to your business. And IP is global, right? We know of all those brands that have global recognition. All right, so we talked about IP in the sense of the business strategy. Now, so let's go ahead and define what is IP. Okay, well, we can look at real property. Real property is tangible, okay, and it adds value to your business because you can buy it, sell it, lease it. Intellectual property is the same. It adds value to your business. You can buy it, you can sell it, and you can lease it. The difference is that intellectual property is a creation of the mind. It is intangible, but it still is a property, and you have rights to that. Okay, so we talked about intellectual property. Now let's talk about the U.S. Patent and Trademark Office. The USPTO is American Innovation Agency, and we are committed to fostering innovation and economic growth, creating a reliable, predictable, and high-quality intellectual property system. The first patent was issued back in 1790 to Samuel Hopkins for a method of making potash and pearl ash, which are materials that were needed for glass making. Okay, so as you can see, the PTO, we've been in business, or actually the patent system has been in business since the beginning of our nation. And we'll see more about that in later slides. Let's talk a little bit more about the USPTO. Back in 2021, we had around 12,000 employees. Out of those, 8,000 were patent examiners, such as myself. We also had about 600 trained attorneys, which are the ones that help with the trademark side. Okay. On average, and even today, we get about 600,000 patent applications. Of those, about 50% get issued. And on the trademark side, back in 2021, we had about 900,000 trademark application, and of those, about 400 were registered or issued. Okay, so intellectual property is an integral part of our nation. It is part of the fabric of the United States. It is enshrined in the Constitution. The founding fathers understood that to create a strong industrialized nation, we needed to provide for our writers and inventors the exclusive right to their writings and inventions. And you're going to see those phrases, exclusive right, need, repeated throughout, okay? Because that is, again, the value of intellectual property. It adds value to your business, to yourself, because you get a right over that property. There are several types of intellectual property. You probably have heard about patents. You certainly have heard about trademarks and copyrights. And I'm sure you're familiar somewhat with trade secrets. Now, I want to stop here for a minute, especially for you guys, small business owners, or people that are just getting started with a business. And I want you to remember that as you develop that business, you may be developing intellectual property in one or more of this different type. So keep an eye for those different type of intellectual property that you are developing as part of your business. For example, let's say that you develop a brand new charging method or a brand new charging device for the next EV system, okay, the next electronic vehicles. Well, you can probably get a patent out of that. So you have a patent, and that's intellectual property, and you can protect it with a patent. But of course, you want to sell that, and you want people to recognize that that charging station was made by you, and you are the source of that good. Well, you're probably going to get a trademark for that. And of course, there's going to be a website in which you're going to talk about how great that charging station is. Well, that website is copyrighted material. And perhaps you may even have some trade secrets in that charging station as well. So keep that in mind, that as you develop your business, you may be developing intellectual property across the different types, and there are different types of protections that you may be seeking. Let's see another example. The iPhone. Everybody knows the iPhone, right? Well, in the iPhone, you have trademarks. You have the Apple logo. You have the iPhone name. You have patents. There are patents for data processing methods, for the semiconductors inside, the antenna, the display. They are copyrights. The software code inside the iPhone is copyrighted. The instruction manuals that you get with a computer, that's copyrighted. Even the ringtones, that musical ringtones that are so familiar, that is also copyrighted. Are there trade secrets in the iPhone? Very likely. We don't know because they're secret. And of course, we're probably very familiar with the design patterns of the iPhone, right? The corner shapes, right? The location of the icons. All those made the news some years ago. Okay, so this is another example again, and I want to reiterate, as you develop your business, you may be developing many different types of intellectual property, so keep an eye on all of those. Let's start now with trade secrets, okay? Trade secrets are not kept by the USPTO. You don't give it to us or we don't keep them for you, okay? Trade secrets are protected by the Uniform Trade Secret Act or by signed agreement between the employees and the companies. Trade secrets last forever, and that's a big value to a trade secret, right? As long as you keep the trade secret confidential, and the secret continues to bring value to the company, you're gonna have a trade secret. Let's see some examples, okay? What is the recipe that makes KFC chicken so delicious? We don't know because it's a trade secret. Google's algorithm for producing those search results, that is also a trade secret, okay? The formula for Coca-Cola is another trade secret. In fact, you are going to see that formulas and recipes are prime examples for trade secrets. So why would you want to use a trade secret to protect that intellectual property? Well, trade secret protects commercially valuable property information like formulas and recipes, or business information that gives a competitive advantage. Trade secrets are not generally known and must be subject to reasonable efforts to preserve confidentiality. Are they kept under lock and key? Are they kept on encrypted media? Okay? And as long as you keep that secret, you're going to get that value. Common ways that trade secrets are lost? Well, failure to take adequate steps to prevent the disclosure. All right? Somebody let the document out in the open. Somebody used unencrypted information to send that trade secret. Okay? The owner can disclose, or owner's authorized disclosure can happen. Reverse engineering. We've all heard about those people that are tinkering away, opening the iPhone, opening computers, looking inside, trying to reverse engineer those secrets. And independent development. Great minds do think alike. So sometimes somebody else can develop the same formula that you develop. All right, let's move on to copyrights. Copyrights are also not kept or not controlled by the USPTO. Okay? However, we do collaborate very closely with the Copyright Office, which is part of the Library of Congress. Let's take a look at some examples of copyrights. Okay, so here we are, some examples of copyrights. Literary works, musical works, both the lyrics and the melodies, dramatic works, motion picture. These are all original works of authorships, and they are all copyrighted. As we said before, the Copyright Office is part of the Library of Congress, and they manage the copyrights. The term of a copyright generally is the life of the author plus 70 years. And as you probably know already, you have developed this type of intellectual property already, because anything you write down, anything that you paint, any photograph that you take, all those are copyrighted, okay? You don't have to do anything to earn that protection. But to gain a strong protection under the law, that copyrighted work needs to be registered with the Library of Congress. And that's something that Again, as you develop your business, you might want to think about getting that strong protection. Okay, let's talk again about what is copyrighted, right? We already mentioned some of this. Intellectual property protection for the, what is the copyright is intellectual property protection for the authors who create these original works of authorship. And remember that an author can be an individual or a group of people, right? Some of the stuff that this includes: literary, dramatic, musical, artists, and certain other intellectual works. What is protected by a copyright? Okay. You all probably have created copyright work, like we mentioned before. If you ever wrote a letter, if you make something out of clay, you have a copyright work. Copyright is self-authenticating. Okay, so take that with you. You can drop that in a cocktail hour. By merely creating that original work of art and fixing it on a tangible medium, you have created a copyright. And remember, fixation need not be directly perceptible, meaning you write that code, you write that letter, if you put it on a thumb drive, that is a tangible medium, and now it's fixated. And then it's copyrighted, just like that. Okay. The requirements, are there requirements for copyright, right? We talked about this, we said anything is copyrighted. You wrote it, it's fixated in a tangible medium, copyrighted. Hold on a minute, okay? Now, copyrights do require a level of originality, which is low, of course. That's what we call a modicum of creativity, okay? So the question then is, what is the bar for a level of originality? Is your shopping list copyrighted? What about a phone book? Is that copyrighted? Does that meet that modicum of creativity? And that I will leave for you to discover, because it's actually quite interesting. So go ahead and Google that. So now let's look at some category of protected works, okay? And we mentioned some of this before: literary works, musical works. Remember, songs, not only the lyrics, but also the melody, sound recording, the ringtone of the iPhone, okay? Dramatic works like movies, okay? All of those are examples of categories of protected works. As I mentioned before, and different to a trade secret that can last forever, a copyright, it has a fixed period of duration, and generally is the life of the author plus 70 years. Okay. So what do you get when you copyright something? Okay. Well, you get the right to reproduce that work. You get the right to prepare derivative, to distribute, to perform and display. And possibly more valuable to you, you get the right to authorize others to reproduce and distribute. Okay, so if you write the next great American novel, then you can give others the right to reproduce and distribute, while you just sit down and let the other people do the work for you. So we talked about copyrights, we talked about trade secrets. Now let's talk about trademarks. The U.S. Patent and Trademark Office is the agency that federally registered trademarks. So finally, something we do, right? By using a mark in commerce, you inherently have a trademark, and you can use that TM, okay? This is something called a common law trademark. So similar to the copyright, that just by writing it on a tangible medium, as long as it has that modicum of creativity, that work is copyrighted. Same thing with a mark that you're using for commerce, okay? However, if you're using your trademark in interstate commerce, you should really register your mark with the USPTO. And this gives you additional protections. Remember, just like the copyright, you can have strong protections. Here, if you're doing interstate commerce, you really want to get those extra protections by registering your mark. And that's how you get that R with the circle. Only registered marks with the PTO, with the USPTO, can use that R. Okay. All of you here today may not have a IP protected under a patent, but arguably all of you have created something that may be protected by a copyright, maybe a web page you're working on, and possibly a trademark, okay? If you have a good or service and you want people to know, to distinguish where that good or service comes from, the source, you probably are looking to get a trademark, okay? Officially, a trademark is any word, name, symbol, or device used to identify or distinguish goods and services and to indicate their source. Some example here that are very well known for us. Again, the apple, right? The apple. The McDonald's golden arches, right? The Girl Scout cookies, which I think we're in season now for Girl Scout cookies. If you're watching this video right now live, Macy's, the Air Jordan logo, okay? All of these are examples of trademarks, and you know the quality of sneakers you're gonna get when you see that Air Jordan mark on it. Okay, so let's formally define a trademark. Like we said, a trademark is a word, slogan, symbol, design, or combination thereof. A trademark identifies the source of your goods and services and distinguishes your goods and services for those of another party. I'm very particular on my coffee, okay? That being said, I try different coffees. And whenever I go to the supermarket, I know, right? You see that wall of coffees, but I know which ones I like and which one to stay away from. How? The trademarks, okay? Trademarks help me identify, oh, this is the coffee I like because it comes from this place, because it's this company that that I have tried and I continue to enjoy. Nope, the other way. Okay, so why would you want to register your trademark? First of all, brand recognition. And of course, you can get that with a TM. TM will give you brand recognition. Public notice of ownership. We talked about letting people know that you have invested in your intellectual property. That's what public notice of ownership is. And again, the TM will give you that, okay? Now, a registered trademark will give you the right to enforce nationally and bring legal action in federal courts. This is something that you only get if you register your trademark with the USPTO. Okay. Similarly, if you want to use the R, those marks are all registered with the USPTO. Very important here, the right to record your mark with customs. If you have goods coming from outside of the United States that are using your trademarks, if it's registered, federally registered, you can then record it with customs and they'll keep an eye on that, okay, to make sure that those goods are the ones you have actual agreement with, okay? It can serve as a basis for foreign filing, and it is published on the U.S. Trademark Database. Right now, I want to stop here and encourage all of you guys, if you are looking to use a trademark, go on to the USPTO.gov and search our database, because you will really want to see if somebody else is already using a similar trademark in the same field. Now, let's take a look at some types of trademarks, okay? Word, right, like the Coca-Cola word, special form of the mark, the cursive Coca-Cola, composite marks, which are, again, symbols that are compositions of other elements, and the design mark. That Coca-Cola shape of the Coca-Cola bottle, that is trademark. And here are some even more interesting examples of trademarks, okay? The Tiffany blue that we all know, whenever you see that blue box, you know something nice is in there, right? So that color is copyrighted. The smell of Play-Doh is copyrighted. The sound of HBO when it starts, all that is copyrighted. So even sounds, colors, and smells can be, I'm sorry, not copyrighted, trademark, it's safe to paper. All of those can be trademarks, okay? However, not all trademarks are created equal. There are strong trademarks and weak trademarks. And we're going to see some of the examples here and what distinguish each other. So the strongest type of trademark you can have are fanciful trademarks. These are completely made of words. Xerox is not a word, it never was, it's just that mark. Microsoft, Cisco, again, all fanciful trademarks, very strong protection. Next level is arbitrary. These are actual words that don't convey any association with the goods or services. Apple, right? We all know apple is a fruit that you eat, as long as it's not red delicious. However, when you see that trademark, you know you're talking about the computer the computer industry, right? The Gap, again, Gap has a meaning, but here is about clothing. And BlackBerry, same as Apple. Suggestive trademarks, okay? They suggest a quality or an intent, desired effect of goods and services. Coppertone, for example, dry food and ever ready for batteries, okay? These are all good trademarks, good examples. Just remember, the strongest is your fanciful. Now, here are some examples of weak trademarks. You really want to stay away from this when you're developing your trademark, okay? Descriptive trademarks. Words or design that describe goods or services, like apple pie for potpourri, right? Now, descriptive marks are much harder to protect than fanciful or arbitrary marks. Again, that's why I keep hearkening and saying, stay away from these. And the lowest or weakest are the generic trademarks. These are common everyday names for goods and services, like milk for dairy products, okay? Generic marks are incapable of being source identifiers, all right? So you're gonna have a very difficult time trying to register these. Now, let's see, why would you want to register your mark with the patent office, okay? First of all, you get nationwide protection. Remember, we talked about that interstate commerce. Second, you can use constructive notice of right to use. The USPTO will refuse later file applications that are confusingly similar, okay? We talked about this database that you guys are all gonna run home and look at after this talk, right? Well, if somebody else applies for a trademark, they're gonna look into that database to see if there are confusingly similar trademarks already, right? You can use the R with the circle symbol. Okay, you have the ability to prevent importation of infringing goods. Remember, you register your trademark and you can register with customs. It can be used for the basis for obtaining registration in a foreign country if you're trying to expand your business outside of the United States. And finally, statutory damages and attorney fees are available in federal litigation relating to your infringement only for registered marks. Okay, we talked about trade secrets, copyrights, and trademarks. Now let's take a moment to talk about patents, which is my bread and butter, as I am a patent examiner. So first of all, what is a patent? Okay, a patent is a contract. That's what it is. Okay, when you receive a patent, you get the right to exclude others from making, using, and selling that invention that you get claims for. However, through the disclosure that you provide the USPTO, you're letting everybody what that invention is. You're letting everybody knows the details of that invention. That is the contract that's happening here. A patent is term limited, just like copyrights. Oh, you know what? I did not say if a trademark was term limited. So let's take a moment here to go back. A trademark is term limited. A trademark can last forever, like a trade secret. However, for that to be the case, that trademark has to be continuously used and you have to renew the registration every 10 years, okay? So that adds value to that trademark. So let's go back here to the patents. Patents are term limited, depending on the type of patents. Utility patents and plant patents are 20 years from the filing date. Design patents are 15 years from the issue date. And patents are territorial. There is no such thing as a worldwide patent. So if anybody's telling you this, you can tell them, hey, I know somebody in the PTO that told me that's not correct. So now let's look at those different types of patents in more detail. We have utility patents, and very likely when you think of a patent, this is what you're thinking of, because utility patents, they protect the inventions, right? For example, a bicycle, a new hat for protecting the sun, and a brand new chemical composition for mixing, okay? So those all go under utility patents. Utility patents are either process, machine, or articles, manufacturers, or composition matter, and they have a term of 20 years from the filing date. The US is a first to file system. Design patents, they protect the way an article looks. Going back to the iPhone, right? The way the icons are organized, the rounded edges, the way the lens are organized on the actual iPhone. Those are all design patents. And then we have plant patents, which protect newly invented strains of asexually reproducing flowers. Okay. In winter and Christmas, where you get the poinsettia plants, there is a patent for that. And you guys can take a look at it. When you're thinking about applying for a patent, you first need to think if your invention is patentable. Is your invention a process, machine, manufacture, or composition of matter? That is the very first hurdle you have to meet. If it doesn't fit on any of these, it is not patentable. Now let's look a little bit deeper at the other hurdles of patenting. For an invention to be patented, it must be novel, non-obvious, and must have a utility. To determine if an invention is novel, examiners will search the prior art for your invention. And what does prior art means then, right? That's the next question. Well, prior art is everything that has been published, other patents, research papers, theses, websites, videos, anything that's out there, we will search. Patent examiners have access to a plethora of databases that we can use to search for that invention that you're claiming, okay, to determine whether it's novel. The second question is more difficult, of course. Examiners must determine if it would have been obvious for someone on the field to combine the prior art to create your invention. As you can imagine, this is a very difficult task. And this is why patent examiners, such as myself, are trained scientists and engineers. The final question for patentability is, does it have utility? Arguably, that's a very low bar. Generally, most inventions have utility, right? A hat covers you from the sun. A shirt keeps you warm. All those have utilities very clear, okay? Examples of those doesn't have utility. A perpetual motion machine. Those don't have utility and cannot be patented. Again, what is not patentable? Well, an idea is not patentable. Okay, the idea of time machine cannot be patented. As great of an idea that is, traveling back in time, one cannot develop a machine that can actually accomplish that task. Therefore, it cannot be patented. Natural phenomena, the northern lights cannot be patented. Okay, abstract ideas like equations or formulas also cannot be patented. Let's take a look at the path to patent, okay? First, you have to have that eureka moment. You have your idea, that invention. Then you may file for provisional applications. We'll look at what that means in the next slide. Finally, or at some point, you will have to file for a non-provisional application that will get examined, and hopefully you get a patent. And again, once you get the patent, you're protected for 20 years from the earliest filing date. So let's take a look at those non-provisional and provisional applications. A provisional application is not examined or published, okay? It has a 1-year limit only for utility patents, so design patents and plant patents, there's no such thing. And really is a low-cost way to establish an effective filing date, an early effective filing date, okay? We talked about the US being a first to file. With that, provisional application gives you that 1 year for you to go out and start using or talking about your invention without fear of somebody to come and file same invention and getting that patent instead of yourself. Now, on the other side, non-provisional application, these are the applications that actually get examined and may become a patent. These are published after 18 months, unless you tell us not to, in which case we won't, okay? And for you to get a patent, you have to file a non-provisional application. So we talked about provisional, non-provisional, we talked about filing. So now let's see what happens to that application once you send it in the mail, actually electronically. We all file electronically these days, okay? Once you file electronically into the PTO, okay? That application is going to go to the desk of an examiner such as myself, right? And you're going to enter in a conversation with a patent examiner, okay? That patent examiner is going to look at your application. It's going to determine whether it's novel, non-obvious, and has utility, okay? Very likely, that application is going to be rejected or objected. However, I don't want you to get discouraged. Again, this is just a conversation. There's going to be a back and forth between you and that examiner until hopefully that becomes a patent. If it doesn't, as you can see in this figure, there are other avenues in which you can try to proceed still, right? You can appeal. And if you no longer wish to continue the prosecution, it can be abandoned. Okay. All right. So I know that was a lot. Hopefully you understand the basics of copyright, trade secrets, trademarks, and patents. And hopefully you understand more than anything that as you develop your business, you may be developing all different types of intellectual property. Okay, trade secrets, trademarks, copyrighted works, or even patents. So keep an eye on all of those. And now that you have a little bit better knowledge of what that means or what that protection gives you, what protection you should be looking for, let's take a look at some of the resources that are available for you right now through the USPTO. Of course, your first stop should be the website, USPTO.gov. Okay? And once you get there, I will suggest you go to the very top tab right here that says Learning Resources. There are so many resources that you can see from there. And I'll show you some here on the other slides, but just go there and start researching. Again, that webpage is packed with resources, especially on that learning resource. Okay. If you are, depending where you are in the United States here, you can contact the different outreach offices. I have the pleasure to be working with the Eastern Regional Office, and we help all stakeholders from Maine all the way to Florida and Puerto Rico as well. Okay, and if you ever have any questions, you can reach out. If you're in our area, you can reach out to the Eastern Regional Outreach Office. And depending on where you are, the USPTO has different regional offices that will provide assistance to you. Okay, so please feel free to reach out. Okay, as part of all the resources that we provide, we have partnered with libraries and universities, and we have stand up several patent and trademark research centers, our PTRCs. There's going to be a professionally trained individual, a librarian, that can help you navigate those resources, can help you search for example, that trademark database can help you search patents and other prior art for the invention. Okay. So here you can see in the map several that we have in Virginia in particular. We have a PTRC in Virginia Tech. And of course, in our headquarters in Alexandria, Virginia, you can come over and visit our public search facility, in which we have experts there that will happy to help you. Okay? Not to mention that it's a beautiful campus. So come and visit. Back in 2011, Congress called the USPTO to stand up regional programs to ensure that under-resourced inventors were being serviced. Okay, and the USPTO answered the call with this pro bono program. Okay, in Virginia in particular, we have the Federal Circuit Bar Association. You can contact them to see if you can qualify to receive these free services, legal services. Again, as you saw a little bit, right, the patent prosecution process can be very complicated, and we do not want any inventor, any entrepreneur to not get the protection they deserve for the intellectual property they have developed just because they don't have the means or just because they cannot understand the process. Okay, so for that, we have developed this pro bono program. Please go ahead and again search our website for the pro bono, and in particular, if you're in Virginia, you can contact the Federal Circuit Bar Association. Another way that you can take advantage of our resources for under-resourced entrepreneurs and inventors is through the law clinic. Okay, here in the law clinics, law students under supervision can provide low cost and sometimes free legal assistance. Again, patent prosecution, can be difficult. It certainly is daunting. And we don't want you to lose on the rights and protection that you deserve after you've done all the works to develop that intellectual property, because you didn't know what box to check, or you didn't understood the language on the application, okay? In Virginia, of course, George Mason University is part of our law clinic, American University, Howard University, University of Richmond, and Liberty University. You can contact them directly, or you can go to, again, our website, uspto.gov, and find, if you're not, especially if you're not in Virginia, you can find the different law clinics on your area. If you are a small entity or micro entity, we have other ways to help you, right? We have reduced patent fees. Again, try to find out if you can qualify for these. More resources for startup in particular. If you are working on a startup, on our website, uspto.gov/startups, great resources there across the entire path, from protecting your IP, planning success, finding funding, okay, engaging experts. There are so many more resources here as well. If you have questions, and I'm sure you have tons of questions after this presentation, you can contact us directly. We have our inventor assistance centers. There you have patent examiners with years of experience manning the phones and manning the emails, okay? And you can contact them, and they're there for you to ask them questions. They're there to answer your questions, okay? Similarly, we have a trademark assistance center, in which you can contact some trademark attorneys. Finally, we have, we certainly have a lot of events that we provide, such as this talk that we're doing here today. And to find out all the events, best way to go find out is on our events webpage. Some of these are in person, most are virtual. So just because you can't make it, that doesn't mean that you cannot participate. We also have a YouTube channel with tons of videos, such as this video that we have today, IP Fundamentals, okay? And now, yes, finally, if you really want to stay up to date with everything that's happening on the USPTO, policy changes, et cetera, events, best way is to subscribe to our mailing list, okay? So hopefully, at the very least, you go there and subscribe so you can keep up to date. And with that, I again want to say thank you to Sheila for letting us participate, and thank you to you for joining us here, and hopefully you got some good information here today.
Thanks, Ramon. My gosh, I think you did such a great job. 2 questions dropped in, they've been answered. I don't see any more, but while we have him here to answer questions, if there are any out there, please drop them into the Q&A, and we'll go ahead and answer those live. That was a lot of great information there.
I know it's a lot. I'm gonna stop sharing. Here we go. Excellent.
Let's see. Okay.
I
Yes,
know
did a great presentation. Okay, I think we have a question here. I filed a trademark without a lawyer last week. Is there a chance it will be rejected? What should I do to prevent that?
No. You're not required to hire a lawyer, okay? That's not the case. In fact, the trademark side of the patent office, they offer these trademark boot camps in which they go over, and these are virtual, once, I don't know if once a quarter. However, on the event page, you can see all those details. But the trademark boot camp not only talks about details of what trademarks are, at the end, they actually help you file as well. So just because you didn't use an attorney, that does not mean that you're going to get rejected. They're going to look at the trademark application you file, and they're going to evaluate it on its merit.
Great. We have another question. When does something become so different from the original that it is no longer a derivative work?
And well, at least I'll talk about patents in particular, okay? And the truth of the matter is that is a very complicated question, okay? There is not a single threshold that I can say, well, if it's 50% more different, then it's novel, right? That's not the case. Every application and every invention again, is evaluated on its merits on its own. It really does have to do with the state of the art or the knowledge on the field at that time of filing. Okay, so sadly there is no hard and fast rule for that.
Should you always require an NDA before sharing information?
I don't feel, I don't think I can answer that question. I think that it's a good idea to have it, but that sounds more like legal advice, and I'm not prepared to answer that. Yeah.
Yeah, agree. Okay, do we have any other questions? Okay, I see a raised hand. If you could please drop your question into the Q&A, please. So this person missed the slides at the beginning on copyright. Is this available? Yes, we're going to send out the slides and the recording in a follow-up email within a few days, so you'll be all set. Question: I created a signature program with the mnemonic habit, but HABIT, but I did research prior. I was told I could not use it because it's a common word.
Well, we talked about, right, the strength of trademarks, right? You certainly are going to be more likely to get that registration if you use a fanciful or strong trademark, right? I cannot speak for that trademark in particular, and I don't know who gave you this advice, right? But all I can do is really reiterate, when you are developing that trademark, try to have the strongest trademark, which is going to be that fanciful trademark.
She wanted to say, what can I do about it? So Phyllis, let us know if Ramon answered that question. Or Ramon, if you want to elaborate a little bit on the one you just answered about habit. Let's see. Yeah.
About
Thanks,
the
Phyllis.
trademark?
You
Okay.
answered it. You answered her question. Okay, so next question. Since I filed a trademark, I've been contacted by many lawyers claiming I need to hire their services for international trademarking, etc. Is that spam?
Again, your best source is going to be the USPTO. Okay, attend our boot camps for trademark before you answer anything, because at the very least you're getting yourself the information directly from the company, not the company, sorry, the from us, right? We are the ones who are going to be doing the registration of those marks. Okay, so before you answer any questions, at the very least, get yourself well informed. Attend one of our boot camps. And just because you're here, that means that you have done the right first step. Okay.
What should I do if the trademark gets rejected?
To be honest, I am not well familiar with the process. I could really speak of the patent prosecution. So sorry about that.
Fair enough. Okay. Any other questions? We have a few more minutes. We got about 10 minutes, so we've got time. Okay, I don't see anything else dropping in. We'll give it a moment, but Ramon, if you have any last words before I close us out, or we'll see if some questions drop in. But
I would like to invite everyone to contact, if you have further questions, you can go ahead and contact our office or your regional outreach office, right? I'm currently working with the Eastern Regional Office. You can search us in the web on the USPTO.gov, and we'll be happy to set up one-on-one meetings, right? We love interacting with our stakeholders. And same thing for the trademark side, okay? The outreach side of the trademark, it's wonderful, and they love meeting their stakeholders as well. And if you have questions, they'll be happy to sit with you on a one-on-one and give you more feedback, okay? So I really do want to invite everyone to do that and come to us. That's what we're here for in the outreach area.
We have someone asking, thank you for the information, and if you could share the trademark boot camp link. So if someone, either you can pull that back up on the screen, or if someone who's helping out in the questions here could drop that into either the chat or into this question, that would be great.
And I think it just ended. So, but it is recurring.
Okay,
I just don't know if it's every quarter or every month, but it is, I think that last week just ended this most
Okay.
recent.
I'm gonna go ahead and share it. Tom did share it here in the chat.
Excellent. Thank you, Tom.
So there we go. All right, any other questions? Right. I think we're good. I'm gonna go ahead and wrap us up unless, again, if you have anything else. I think we'll go ahead and close out. I know you have other things today.
Beautiful. I'm
Great.
happy to be here, helping you guys.
Great. So I will go ahead and close this out. I want to thank everyone for attending. Ramon, thank you for a fabulous presentation. You will receive an email with a link to the recording and the slides. If you would like to sign up for upcoming webinars or access recorded webinars, please visit virginiaspdc.org/training. These resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiaspdc.org or via our website, and we hope to see you at our next sessions. Take care, everyone. Bye.